Hello, my name is Natasha Sarah-Lorraine, and as an attorney in Atlanta, a fair bit of my practice involves employment law, where not only do I defend companies in the face of litigation, but I also provide advice and counsel on a variety of employer-employee relationship matters. For example, advising clients on new laws and regulations like the Families First Coronavirus Response Act, which we know went into effect April 1st of this year, which was last Wednesday. Today, I want to briefly discuss the Families First Coronavirus Response Act, otherwise known as FFCRA, just to give you some guidance, a high level view of this statute, and what employers need to know so that they can make sure that they're complying with the statute if it does apply to them, because it doesn't apply to every employer. And we'll talk more about that. I know there's a lot of literature out there, there's a lot of guidance, and I think this video will be helpful because it's kind of a quick high level view of what you can expect with this statute and what you need to know as an employer. I do want to advise you that if there is an issue that you're experiencing in your operations that is specific to you, you definitely need to contact a lawyer or your lawyer, because you want to make sure that there are no missteps with regards to this statute or really any federal statute or state or local regulation or ordinance. Please feel free to share this video, repost it. You can post comments if you have any questions that I might be able to assist you with. I hope to have another video covering even more about the FFCRA and any other applicable statutes that affect us right now in the face of COVID-19. I'm hoping to have them posted every other week. It really depends on my caseload because I am a practicing attorney, so I have cases that I'm working on. So depending upon that, that will affect the frequency of the videos. But I think you will find this to be very valuable, so enjoy. Let's talk about the FFCRA. Exactly what is it? So this requires employers with less than 500 employees to provide paid leaves to their employees for COVID-related reasons. It likewise applies to government or agency employers with one or more employee. And employers may wonder, how do I know how many employees I have? How do I calculate my workforce? You will focus on who is on your payroll. So you want to do an audit of your payroll, and you will include any full-time, any part-time employees, any employees that are currently on leave, whether there's an employee that's on medical, military, or personal leave, they will be included in your workforce. In addition to that, you want to include temps or day laborers, even if they're supplied from a staffing agency, because there could be a joint employer relationship. There's a little more analysis that will go into that, but just from a high level view, it depends on how continuous that relationship has been, so you may be including them in your count. You will not include independent contractors. Those are 1099 individuals. So someone that's not receiving a W-2 from you, you would not include them in your count. Some employers may have this information readily available to them. Some employers have HR departments or payroll departments, but for some of our small businesses or smaller businesses, it might be a one-man shop. So you may not have a count of your workforce readily available to you, and it's okay if you do not. But if that is you, you want to do an audit of your workforce as soon as possible, like today or shortly thereafter, because you want to know if you are subject to the FFCRA. So you would want to pull your payroll. You want to see, once again, who's full-time, who's part-time, who's on leave right now, who are our day laborers or our temps that are working with us. And you want to perform a count as soon as possible so that you can make sure that your operations are in line with the FFCRA regulations. Please keep in mind that if you are an employer with 500 or more employees, while you may not be subject to the FFCRA, there is the original Family and Medical Leave Act that you have to abide by. There are other federal laws as well as local and state ordinances and statutes. So you want to be familiar with your state and your local statutes as well. For example, in Georgia, we do have the Family Care Act that does allow employees to take up to 5 days of accrued sick time to care for a family member. So this is something that may fall within that bucket. So you want to make sure that while you may not be subject to the FFCRA, that you have familiarities with other statutes that are federal, local, or state mandated that you must comply with. The FFCRA is separated into two separate provisions. You first have the Emergency Paid Sick Leave Act. The second is the Emergency Family and Medical Leave Expansion Act. Let's first talk about the Emergency Paid Sick Leave Act. So this provides every employee, no matter how long he or she has been employed with you, the ability to request leave for qualifying reasons. So under the Emergency Paid Sick Leave Act, an employee can request leave to care for self. So self-care, in other words. Let's say the employee is subject to a quarantine or isolation order that has been mandated federally, statewide, or locally. For example, here in Georgia, we have a statewide shelter in place that went into effect and is effective until April 13th. So that is an example of that. An employee can request leave under the self-care prong of the Emergency Paid Sick Leave Act for a reason like that. Another is, let's say the employee's healthcare provider has advised the employee to self-quarantine or isolate because he or she is experiencing COVID-19 related symptoms, or he or she has tested positive for COVID-19. Those would be qualifiers under the self-care prong. Now here an employee can take up to 2 weeks, no more than 80 hours, and will receive 100% of his or her regular pay rate. Now that cannot exceed $511 per day. They do cap it at $511 per day, which calculates out to a total of $5,110 for the duration. So that is the self-care prong. The second is care for others. So an employee is allowed to request time off under the Emergency Paid Sick Leave Act also if they have to care for someone else. For example, if there is a minor child that is under the age of 18 that the employee is caring for, that is home because their school's unavailable or closed, or their daycare is unavailable or closed due to COVID-19 related reasons, that would be a qualifier under the care for others prong. Also, if there is someone that the employee is caring for or that is in the employee's home that is subject to a quarantine or self-isolation order that the employee is caring for and they're unable to work or telework because of that. Now, the care for other prong allows the employee to take up to 2 weeks, no more than 80 hours, but the employee at this time would be receiving 2/3 of their regular pay rate. It would not be 100%. And there's also a cap with that. So it's no more than $200 per day and no more than $2,000 for the duration of that time period. The second provision under the FFCRA that I want to discuss is the Emergency Family and Medical Leave Expansion Act. Now this requires the employee to be employed with you for at least 30 calendar days, not business days, at least 30 calendar days. And what this does is it provides an additional 10 weeks to the employee who needs to take leave to care for a minor child that is at home because their daycare or school is unavailable or closed for COVID-19 related reasons. So for example, if you have an employee that has been working with you for, let's say, 31 days, and they come to you and say they need to take time off because they're unable to work or work remotely because of a child they're caring for that is home because either their daycare is closed or their school is closed due to COVID-19 related reasons. So here the employee would qualify for the Emergency Paid Sick Leave Act under the Care for Others prong. In this instance, the two leaves would run concurrently. So the first 2 weeks would be covered under the Emergency Paid Sick Leave Act, and then the remaining 10 weeks will be covered under the Emergency Family and Medical Leave Expansion Act. So what type of documentation is required for an employee to request leave under the FFCRA? Whether they are requesting leave under the Emergency Paid Sick Leave Act or the Emergency Family and Medical Leave Expansion Act, they need to provide documentation. So that would look like either a note from their healthcare provider. Please keep in mind that an employee cannot unilaterally decide to self-quarantine or isolate and expect to be paid. There needs to be some documentation to protect you as the employer for you to provide leave under the FFCRA. So they would have to have some sort of documentation from their healthcare provider noting that they are requiring them to self-isolate or self-quarantine. The employee can also provide a quarantine or isolation order if it's something that has been mandated on a federal, state, or local level. Also, if the employee is requesting leave due to their need to care for a minor child, they can provide notice from the daycare or the school, a newspaper clipping, something just to evidence that the school or the daycare is closed and unavailable due to COVID-19 related reasons. Now, you may wonder if there are any exemptions. You might be a smaller employer and think, if I comply with the FFCRA, this is going to tank my business. Fortunately, there are some options. Now, if you are a smaller employer with less than 50 employees, you may be able to claim that compliance with the FFCRA will be damaging to the viability of your business. And that's only under the circumstance where an employee is requesting time to care for a minor child. So remember, under the Emergency Paid Sick Leave Act and the Emergency Family and Medical Leave Expansion Act, there are qualifiers where if an employee needs to care for a child under the age of 18 because their school or daycare is closed due to COVID-19 related reasons, they might be able to take leave under the FFCRA. But like I said, if your business that's smaller, that has less than 50 employees, and you think that that's going to damage the operations of your business, you might be able to claim an exemption for those reasons. But there are some things that you would have to prove in order to qualify for that. There are specific industries that are exempt from the FFCRA, for example, healthcare providers or emergency responders, and a variety of other industries. So like I said at the onset of the video, you want to make sure that you contact a lawyer or your lawyer so that you can understand if you fall under the exemptions, and also make sure that you're complying with the FFCRA if you are subject to it. Thank you so much for watching this video. I know it was a lot of information that was jam-packed in here, but I'm grateful that you took the time to watch the video. I hope you took some notes. If you have questions, feel free to direct message me. You can leave the questions in the comments, but know that more than likely I will direct message you with a response. I do also want to encourage you to follow me on my Facebook page, on my LinkedIn page, and Instagram. I will include that information in the caption. I hope to see you next time, and between now and then, be safe, be well, be healthy, have a wonderful day.